So I'm going to talk about some other title issues that are common in North Dakota and other states. The first one is highways. Obviously, when you're doing title opinions, you're going to have conveyances for highways, both to the state highway department, to counties, and a lot of times those deeds do not have mineral reservations in them. They do now, but back in the 30s, 40s, 50s, a lot of them did not have a mineral reservation, and they were warranty deeds in many cases. So the question arises, were the minerals conveyed to the highway entity, the county or the state, when these deeds were executed? But in North Dakota, no fluid minerals, such as oil and gas, were conveyed. Even if it was a warranty deed without any mineral reservation. The reason being, we have a statute in North Dakota that was passed where the state essentially gave up, conveyed back fluid minerals in any deeds that might have been acquired by the state and highway department for highway purposes. So it's pretty clear there. And the theory that the courts have gone on, if they've been asked to interpret, were minerals conveyed or not, is they generally say not, under the theory that if the land would have been taken through condemnation, the entity condemning would only get what it needs, usually an easement, thus minerals would not be obtained. So when the courts have been faced with these issues to try to interpret, they usually say minerals don't go. But in North Dakota, at least with our law firm, we believe that if you have county deeds back in the 20s, 30s, 40s, 50s, whatever, typically they were warranty deeds. There was no mineral reservation. We still flag those. There is a North Dakota Supreme Court case which construed a county deed and determined that the minerals did not go, using that same analogy that had they condemned, they would have only gotten an easement, obviously no oil and gas, but there are some very specific facts in that case that at least caution us to say that when we have these old county deeds, we're probably still going to flag them and ask the county to execute a disclaimer or something. Also, the common roads we have in North Dakota are the section line roads. If you do title work in North Dakota, you're familiar with, we have a law that was passed at statehood that said any section line, 33 feet on each side, is open for public travel. And so they're essentially a road. But under our law, under section line roads, the adjacent landowners own the land subject to the right-of-way of the section line. They own the land, including the minerals underneath the section line road. And so if you're ever wondering, we have section line roads here, 66 feet. Did the state keep the oil and gas or get the oil and gas under those section line roads? The answer is no. It's really more just in the form of an easement. Another common issue that you'll see as title examiners are railroads. We have a lot of railroads in North Dakota. We have the original Great Northern Railroad, which runs from all across the northern half of the state from Grand Forks through Williston. We have the old Northern Pacific, which runs from Fargo through Dickinson, Medora, and on out. These are known as charter or mainline rights-of-ways because they were given their rights-of-way by acts of Congress. So if you're examining title to a tract of land, let's say near Williston, Stanley, wherever, and it's got a main line, the old main line of the Great Northern Railroad in it, you're not going to find any deed or document conveying land to that railroad. They were given to them by, as I say, by acts of Congress. Then they would go through a process coming out here and they'd survey the land, do a map of definite location, file that with the Federal Land Office. The Federal Land Office would say, yeah, you're good to go, it's your right of way. But there's nothing recorded. So it's kind of a cautionary to you you know, if you're in and around land that has near the main line rights of way, you're not going to find it of record. You have to look at an atlas or something that hopefully gives you some clue that it's there. But these rights of ways in North Dakota were given under two very distinct acts. The old Northern Pacific line, which, as I say, runs through Dickinson, Medora, that was either under the 1862 or 1864 acts. These are kind of strange laws, but the minerals are in the USA. They were retained by the USA except the coal and iron, which went to the railroad. So if you're doing title on a charter right-of-way tract like around Dickinson or Belfield, and you have the charter right-of-way of the Northern Pacific for a certain acreage, the USA kept that oil and gas. Now there's kind of a unique leasing procedure that you have to go through where I think the railroad is actually given a right to first make the first dibs on leasing that tract, but they are leasable. But the oil and gas is owned by the USA under that Northern Pacific charter line rights of way. Now, if you're up in the northern part of the state, where the old Great Northern used to run, that was under the Act of 1875. Under that law, that is easement only to the railroad. Title to the minerals, when the lands were subsequently patented out, and the patent to Joe Smith for the Southwest Quarter 1, if it had the Great Northern Charter right-of-way in it, that patentee got title to all of the land, because it's merely an easement, and also, of course, received title to the oil and gas. So there, in that situation, a lease from the landowner would lease oil and gas. The third situation, which you commonly see in North Dakota, especially in the northern part of the state, Divide County, Burke County, Renville County, up Williams, Montreal, are deeds. Deeds from landowners to the railroad for a right-of-way. And at least in my experience, the deed form that was utilized was virtually identical across that northern tier. But the issue is, it's a deed. It reads and sounds like a warranty deed. It has no mineral reservation in it, typically. Those old deeds from turn of the last century, 1903, 04, 05. The question is, did oil and gas go to the railroad or not? Now, we have an older North Dakota Supreme Court case, a Rosenquist case, which discussed this issue in a related way. The title to the minerals wasn't specifically at issue. And we have a more recent North Dakota District Court case, both of which indicated that fee title was conveyed, not just a right-of-way, not just an easement, but fee title. All the attributes of a warranty deed were there. So fee title was conveyed. There was no mineral reservation. So the railroad got the oil and gas. Now, like I say, we have an old North Dakota Supreme Court case, which is somewhat on point, but gives a lot of credence, and we've relied on that quite a bit in our law firm. We have a more recent North Dakota District Court case where the title to the oil and gas was specifically at issue, and the district court held that the railroad got the oil and gas. But we are aware there are several cases still pending out there. I think they're in Montreal County, where other parties are still attempting to litigate this issue, and of course trying to knock the railroad out from railroad ownership. So we feel pretty comfortable in our law firm, and we see these deeds, and we will say typically that the railroad got the oil and gas, but we may yet have a definitive decision. The one district court case I mentioned was not appealed to the North Dakota Supreme Court. There's a case or two that are still pending in the district court. They're a ways from resolution even at the district court level. And so with Supremes, we just don't even know if it'll get there and when it might get there. The next issue I'm going to talk about are royalty interests. And I was kind of curious, how many law students do we have in the room? Okay, we've got a few. Royalty, when I was in law school, they always said, when you own a piece of land, it's like a bundle of sticks. And when you have all the sticks, you have all the ownership rights, you know, to do with it what you will. But you can sell off a stick, if you will. Well, like if you own a mineral acre, okay, you have the right to lease it. You have the right to drill your own well if you want. You have the right to production. But what you can do is you can strip off or convey off from that mineral interest a royalty interest, which is only a right to production. You can't lease it. You don't have the right to develop it, but it conveys off a right of production. And we have a lot of royalty conveyances in North Dakota that occurred back in the 30s, 40s, 50s. Some of those tracts, if you've done title in McKenzie County, they're just awful. You know, you might have 30, 40 royalty deeds that started off by when some guy bought 5% royalty and went and sold all his friends and neighbors a 1/4% royalty back in the 40s or 50s or even earlier. And now they're all deceased. You have probates of them, and maybe their kids are deceased, and you've got probates of them. You know, there are some of those tracts out there where you can literally have hundreds of royalty conveyances, separate from the mineral title, just royalty. And, you know, if you're a landman leasing for oil and gas, you don't really care too much. But if you're a title examiner like us, doing a title opinion, they become very important. You have to deal with them. You have to try to determine what was conveyed. The problem with these royalty conveyances is that they're often ambiguous as to what was being conveyed and how much was being conveyed. So one of the first issues you have to do when you have a royalty conveyance, you have to determine what type of royalty interest was conveyed. You have to determine the fractional royalty interest that was conveyed. And kind of a tangential issue, especially in Montana, is even though it says royalty deed, was it really conveying royalty? Or if you read the wording of the deed, was it conveying minerals? Montana is really difficult when it comes to interpreting deeds, royalty deeds, because there are several Montana Supreme Court cases which have actually construed royalty deeds as mineral deeds. But it's difficult, and so it's typically not an issue in North Dakota if you have a royalty deed. Is it conveying royalty or minerals? You know, we're usually pretty comfortable in saying it's conveying royalty. But what type of royalty? There are two types. There's the fractional royalty, which is a fraction or percentage of the gross production. It's not reduced by a lease or anything else. And then there's the fraction of royalty, which is a share of production in the amount of the fraction, let's say 5%, times the lease royalty. Something you probably don't consider, but the issues are out there. It's in our mineral title standards. A fractional royalty, these are words where courts have construed them as fractional royalties. An undivided 1/6 royalty interest, a 1/4 royalty in all the oil, gas, and other minerals, 1% royalty of all the oil and gas produced and saved. So courts have interpreted those as the fractional royalty non-reducible by any lease royalty. Fraction of royalty. These are courts have interpreted these as conveying fractions of royalty, which is let's say a 5% royalty was conveyed, it's reduced by the lease royalty. 1/16 of all oil royalty. And 1/2 interest in all royalties received from any oil and gas lease. That one's pretty clear. And undivided 1/2 interest into all the royalty. So if you look at the two, read those, what's the difference? I can't give you a firm line of demarcation to say what is the difference. I think when they, in the fraction of royalty, where they go 1/16 of an undivided 1/2 interest into all, I mean, it's very hard to tell. As I mentioned, distinguishing the two, it can be very difficult. But the difference can be significant, especially when if you're doing a division or a title opinion, which we do a lot of, which after a well's been drilled, we have to go through all these royalty conveyances. We have to tell our client who owns what in exactly what percentage, so that each royalty owner, mineral owner, working interest owner can get their specific net revenue interest, which has to add up to 1 when we're all done. So we have to make this call, make this determination, and the difference can be huge. A 1/16 fractional royalty is a fraction of all the production. That would be 6.25% of the production in, let's say, a particular tract. A 1/16 fraction of royalty, let's say it's subject to the mineral owner who conveyed out this royalty has signed a lease, which is a 1/8 royalty, so, okay, 1/16 fraction of royalty of a 1/8 lease is 0.78125% of production. Huge difference, huge difference. And obviously when we're writing up division order title opinions, we have to make this call. As I said, the conveyances are often ambiguous. There are all sorts of different ways courts have interpreted these conveyances, but what you have to do is, what we do is we pull out our mineral title standards, we look at the title standard on fraction of royalty and fraction of royalty, we look at the cases that are cited there, we try to make a determination, which is it? We probably write our title opinion to the way we think it is. Sometimes they're clear. Sometimes royalty conveyances are clear, but oftentimes they're not. And so we have to make this determination. So oftentimes we will make a call, but we'll ask for a stipulation of interest if it's not clear. If we can't tell if it's a fractional royalty or fraction of royalty. I was also going to mention, Chris touched on it too, the Acoma and the Wenco cases, which dealt with how do you share these burdens. And, you know, it points out that this isn't just a unique issue that rarely occurs. It's a subject, at least partial subject, of 2 North Dakota Supreme Court cases, the Acoma case, which Chris mentioned in 1991, I think, and the Wenco case, which just came out last year, where one of the issues they're fighting over is who bears this outstanding royalty. And I'll just give you an example. In 1938, A owned 100% of the minerals and conveyed a 5% fractional royalty, okay? Full 5%. A later conveyed 75% of the minerals, so that today his heirs only own 25%. Not an uncommon occurrence at all if you examine many mineral titles. The 25% mineral interest is subject to a 1/6 royalty. That's, if you factor that out, you know, what's 25% of 1/6? It's 4.16%. A's heirs own 25% of the minerals with a 1/6 royalty, netting them 4.16. They're already subject to a 5% outstanding royalty. Okay? Who bears it? Which mineral owners have to be burdened by that royalty when you're preparing a division or a title opinion, figuring out who gets paid what? So that's a dilemma that, as at least as title examiners, you're going to be faced with. Now, as Chris mentioned, in Acoma and Wenco, the Supreme Court indicated that if the grantor, in my example A, still has enough mineral interest to bear all that royalty, they will typically have to bear it. Most of these royalty deeds have warranty of title clauses in them. They never say they were, when they conveyed, or excuse me, when after A conveyed the royalty, then he conveys 75% of the minerals. Those mineral deeds typically don't say subject to outstanding royalty burdens. There are warranty clauses in them. So the Supreme Court said if A's heirs have enough, they should bear it. Now let's say if A had only conveyed 2% royalty. A's heirs have a 25% mineral interest left, subject to a 1/6 royalty of 4.16%. They got enough. They can bear it. And that's how we'll write the title opinion. A's heirs are going to bear that royalty. But in my example, they don't. They're essentially, even though they still own minerals, they sign leases, they're zeroed out. They get nothing because they're subject to that royalty. So, but what do? There's still not enough to who bears that excess royalty? Well, the Supreme Court indicated, that, but not decided, that if we have the example that I've given where A gave that 5% royalty, his heirs don't have enough anymore, you're probably going to have to proportionately distribute that royalty burden amongst all the mineral owners, even though they got mineral deeds with warranty clauses, no subject to outstanding royalty. What else are you going to do? You're probably going to have to make them all bear that burden. It's, we don't have a definitive case on it yet, but they've indicated, and our title standard, which Chris mentioned and cited earlier, kind of indicates that's what you'd have to do. I mean, if we're faced with that situation and doing a division or a title opinion, we're going to probably do it that way. We'll probably make them all bear it, but we're going to ask for a stip. We're going to, stipulation of interest. I mean, we've made a judgment call. We don't know how this is going to fall out. We don't know if parties are going to want to litigate it. You have to do something, but that's what we do. So for title examiners, you have to be aware of the law in your jurisdiction. If you see these royalty conveyances, you're not sure which type of royalty was conveyed, you've got to flag it. Any ambiguity must be clarified by a corrective deed, stipulation of interest, quiet title action. Next issue I'm going to get into is transfer of mineral acres by fractional interest or mineral acres. For a lot of you, this is a common occurrence. You do it every day, but the common example is a mineral deed conveys an 81/60th mineral interest, stating the land to convey 160 acres, say the Southwest Quarter, Section 1. But you're examining title. Southwest Quarter 1 isn't a full 160-acre quarter. It's only got 158 acres in it. The deed conveys an 81/60th mineral interest. Well, what happens? Well, if you take 81/60th times 158 acres, they get 79 acres, even though the deed says 81/60th. But what if the land is not a short quarter section where the lots don't add up to 40 acres, but it's a larger quarter section where the lots equal more than 40 acres, let's say 162 acres, what's an 81/60th interest convey? It conveys 81 acres. And then, as you've also probably all seen, a lot of these mineral deeds also have an intent clause in them. And in this case, they would typically say intent to convey 80 mineral acres. Well, you've got an ambiguity if you're in a short or a long piece of tract of land. You've got an 81/60th granting clause, you've got an intent clause to 80. Different result. We typically will give credence to the intent clause as reflecting the intent of the parties, write up the title opinion, giving the grantee 80 mineral acres, but you still got an ambiguity. We'll probably ask for a STIP. Why is that? It's because the Little Missouri River was in there, is in there. Okay? So the difference in this example, in this case, was 20 acres due to the non-navigable river located in the section. But it's still a true 640-acre section of land. A executes a mineral deed to B, conveying an undivided 3/10/6/20th interest in all of Section 1, stated to cover 620 acres, picking up from what the patent said. The issue is whether the mineral deed conveyed any interest in the 20 acres under the river. A asserts that a 3/10/6/20th interest is limited to 620 acres, so 310 mineral acres were conveyed. B asserts that a Section 1, which it said it conveyed it in, contains 640 acres, that he acquired a 3/10/6/20th interest in all 640, being 320 mineral acres. So this was litigated. The North Dakota Supreme Court determined that the grantee acquired the fractional interest in all 640 acres of Section 1, and B received 320 mineral acres. And this is another case where they cited the North Dakota Mineral Title Standards, which Chris mentioned, as authority on this issue, and they followed it. So some kind of general rules that come from this, where if a grant is of a fractional or percentage mineral interest only, no intent clause, they will gain by an excess of acreage and lose by a shortage of acreage. A grantee of undivided mineral acres will typically neither gain nor lose by an excess or shortage of acres if it's strictly a grant of mineral acres. If the deed conveys land stated to cover a specific number of mineral acres of more or less, and like the example I just gave you, it said 620 acres more or less. The deed will convey the interest in the entire tract of land if the acreage call is incorrect, which in the North Dakota Supreme Court case, which I just mentioned, they said conveying Section 1 contains 620 acres more or less, but all of Section 1. Court said no, you said all of Section 1. The fact that you used 620 acres was an error. That's not determinative. We're going to use the lands that you said. So in my example, or in that case, all of Section 1. And if a discrepancy between the specific description of the property conveyed and a statement of the acreage is my prior example, again, the specific description will be controlling all of Section 1. So this is a classic example, like if you see deeds where like they convey 28/40th mineral interest in 5 different, let's say, sections of land, where what they've done is they've gone in and figured out that the grantee has figured out, well, the grantor owns mineral acres in 4 different quarters of land, but he owns different interests in each quarter. But I'm only going to buy 20. He owns 80. I'm only buying 20. So I'm just going to say 80 6/40ths in these 4 quarters. But if when they own different interests in each quarter, that is not going to work. You cannot lump all, say I'm going to buy 20 acres in these 4 different quarters where the grantor owns different interests in each quarter and just lump it all together and say 20 6/40ths. Almost invariably, it's not going to work. You're going to be short in one quarter, long in another one. If you're ever doing mineral conveyances, you're buying or selling minerals where the grantor owns varying interests in the different lands, specify in each tract, I'm going to buy 5 acres in this tract, 4 acres in this tract, 10 acres in this tract. Don't lump them all together in my example and say 20 6/40ths, because invariably you're going to have an ambiguity and in one or more tracks, and STIPs are going to have to be required, that kind of thing. The last issue I'm going to talk about is extension of overriding royalty interests. And this is becoming a much more common issue these days, and it's a kind of a scary scenario for title examiners. But in the example I have here, we have a 2007 oil and gas lease taken by Company A, primary term of 5 years. Company A, the original lessee, assigns all interest in the lease to Company B. A retains an overriding royalty interest and states in the reservation of overriding royalty, which will extend to all extensions or renewals of this lease, or let's just say any new lease taken within 1 year of expiration of that lease. There are many variations on that extension renewal language that you'll see, but that's kind of the general gist. In 2012, before the 2000 lease expires, Company B obtains a top lease. You all know what a top lease is, right? It's a lease obtained in anticipation of an earlier lease expiring. It hasn't expired yet, but so you go out and get a top lease, which says this top lease will take effect on a certain date, usually a few months in the future, when the bottom lease hopefully expires. That's what a top lease is. So Company B obtains a top lease. Now, you're examining title. The top lease is the effective lease. Now, it's under production. You might tend to ignore that 2007 lease. You know, it's expired. Yeah, there was an override on it, but hey, the lease is gone. Well, no, it's not. Because of the extension renewal clause, which A had in its conveyance to B, and because B took the top lease, B is bound by that prior agreement, and almost invariably, A's override from the 2007 lease is now going to apply to the 2012 lease. These are very difficult issues to spot, especially if you're examining long and difficult titles where it's difficult enough to identify the current leases, the burdens on them, determining who owns what, figuring out all the net revenues, to think about and go back. Oh, I just better, double check. Is there any chance I might have an extension of override issue? Now, the courts seem fairly uniform that there is no right to an extension or renewal unless there is an extension or renewal clause. Okay? There are a few exceptions where courts have found a duty of fair dealing, but typically the courts have said, we're all big boys here. We know what we're doing. We're in the mineral business. If you wanted to that override to extend when B got that top lease, you should have put an extension renewal clause in there. But another example is, what if B, the 2007 lease expires, but within that time frame, I mentioned a year, B gets a new lease. Override probably extends because it's within that 1 year. What if the extension renewal clause didn't say anything about 6 months or 1 year hereafter? But a week or two later, 3 days later, after the 2007 lease expires, B gets a new lease. Does it extend? Not clear. Not clear. So it's a very, if you're a title examiner figuring out net revenue interests, even if you're leasing for a client and you're just running title and thinking these 2007 leases are gone, I'm leasing for you know, company C or company B, you know, is there potential for an extension renewal? And a related issue, which happens with some of these, is what if, okay, the override does extend, but the 2007 lease had a 15% landowner's royalty, and the override was 20% less lease burden, so 5%. 2012 lease is now taken, the top lease. It's got an 18% landowner's royalty. Well, A is going to say, I don't care that you did that, B. I get 5%. B is going to say, wait a minute. You know, I've got an increased burden here. You should be netted down to 2. This issue is not really resolvable by title examination. And who's going to, you know, bear that overriding royalty burden? Does A get reduced? Does B have a, you know, is that 18% royalty lease really now a 23% royalty lease? What if the working interest owner says, well, you guaranteed me a net 20% net revenue interest when you sign that lease? So, I get to reduce you down. I mean, it's just, these are all kind of related issues that come up in title opinions that we have to try to resolve as title examiners. Obviously, this is going to call for a stipulation of interest. So again, this is really just to make you aware of this issue, that it's out there, that it could come to haunt. You know, where we see it haunting some of our clients is this transaction occurred between those parties back in '07. My ultimate oil company client gets a lease from B, doesn't think about an extension of an override from way back when, and all of a sudden, you know, your client oil company who's drilling this well, you call them up or write them and say, we're probably going to throw on a 3 or 4% extra override burden on your working interest that you may not have known about. You know, so that's the issue it creates. So just a heads up. So I guess with that, I got a little time left if you have any questions for us.